How to contest a will in Georgia. Understanding the intricacies of contesting a will in Georgia is crucial, particularly for those who believe a loved one's final wishes have not been accurately reflected or legally adhered to. A will contest is a formal objection raised against the validity of a will, based on specific grounds such as improper execution, undue influence, or the testator's lack of mental capacity. These legal challenges can be intricate and emotionally taxing, but they are essential for ensuring that the distribution of the estate is just and in accordance with the law. Legal grounds for contesting a will in Georgia. In Georgia, contesting a will requires valid legal grounds. These typically include improper execution. A will must meet specific legal requirements to be valid. If the will wasn't signed correctly, lacked necessary witnesses, or didn't adhere to other statutory mandates, it might be contested. Undue influence. If someone exerted excessive pressure on the testator, causing the will to reflect the influencer's wishes rather than the testator's true intentions, the will can be challenged. Lack of testamentary capacity. The testator must be of sound mind when creating the will. If the testator lacked the mental capacity to understand the implications of their actions, the will might be invalidated. Fraud or forgery. Any will created under deceitful conditions or containing falsified elements can be contested. Proving fraud or forgery often requires substantial evidence such as handwriting analysis and witness testimonies. Steps to contest a will in Georgia. File a caveat. The first step is to file a formal objection, known as a caveat, with the probate court handling the estate. This must be done by an interested party, such as a beneficiary or heir. Gather evidence. Collect all necessary documentation and evidence supporting the claim. This can include medical records, witness statements, and any proof of undue influence or improper execution. Probate court processes. Once the caveat is filed, the court will review the submissions. If the court finds sufficient cause, it will schedule further proceedings, including pre-trial conferences and discovery phases. Present the case. During the trial, both sides present their arguments. This may involve calling witnesses, including professional witnesses like psychologists or handwriting analysts, to testify on relevant matters. Adhere to deadlines. Georgia law imposes strict deadlines for contesting a will. Missing these deadlines can result in losing the right to contest, so acting promptly is crucial. Legal representation from a knowledgeable attorney is highly recommended to navigate these complex processes effectively. For those in Atlanta and the surrounding areas, Trace Brooks Law offers guidance on probate matters. If you believe that a will does not truly reflect the intentions of a deceased loved one, or if you suspect that the will was not properly executed, seek legal guidance immediately. Our experienced probate attorneys at Trace Brooks Law can help protect your rights and ensure justice is served in the distribution of the estate. Contact Trace Brooks Law today at 404-492-9559 or visit us at 1275 Peachtree Street, Nebraska number 525, Atlanta, Georgia 30309, United States to explore your options and take the first step toward resolving your concerns with the will in question.